Hi, this is David Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So I've hit on this theme before, but I think it really bears repeating and driving home the example, which is you take a real big chance in physically separating when you're about to go through a divorce or you've already filed for divorce and you don't have interim agreements and orders in place. What do I mean? So you and your spouse should be on the same page as to custody, parental access arrangements, who pays what in terms of expenses of the house, or how the mortgage is going to get paid, how the utilities are going to get paid, how child support is going to work if that's applicable, alimony, otherwise known as spousal maintenance. All of that has to be worked out. Here's the danger. If you guys separate, let's say, the usual circumstances, father moves out, and then there's a disagreement as to how much dad is paying in terms of child support. Whether, who pays what on the mortgage. Hey, father might say, well, mom's living in the house. Why should I pay for a house I'm not living in anymore? I have my own rent over here. Inevitable disagreements come up about, I thought we were going to do shared custody, which otherwise means 50-50 time. And now mom is saying I only get alternate weekends. The problem is that if you delay on those things, you don't have an interim parenting agreement in place, then you're going to go in, you're going to see the judge. The judge is going to say, sorry, I can't really decide anything in terms of parental access, especially without assigning an attorney for child first. So then they're going to delay the case for about a month or so for the attorney for child to speak with the kids. Then they're going to come back, and then the judge is going to say, has an interim agreement been reached? Oh, no, it hasn't been? Oh, okay, well, now we're going to have to delay the case even further because we're going to possibly have mom and or dad file a written motion, otherwise known as an order to show cause, for a court order. And maybe the judge says, maybe I need some kind of mini interim hearing on setting parental access. Same thing in regards to child support. Judge may very well say, hey, look, I'm not going to decide that issue without a formal motion being filed. Well, especially if mom is the one that wants child support from dad. Dad moved out. Dad's making 6 figures. He could otherwise afford to pay child support. Well, here's the danger. A motion is going to take months to get done. So even if, let's say right away, mom goes to dad and says, I want you to pay X amount in child support. And dad says, no, I'm just not going to do that. I'll pay a little bit, $500 a month or something. And, if that's well below guidelines. Now mom goes to her attorney. She says, we got to file a motion right away. Great, file a motion. Guess what happens? A motion schedule is set up. Dad gets to file a response. Usually takes at least 2-3 weeks, sometimes a month. Then mom wants to file a response to that. That takes another 2-3 weeks. Then, presumptively, the judge has up to 60 days to render a decision. Maybe they do it faster. Maybe they take longer than 60 days. Just even on that time frame, you're up to 4 or 5 months without getting sufficient child support. So you really take a big gamble at saying, we're going to keep the peace, we're going to physically separate, but you don't have those interim parenting agreements in place. So talk to your attorneys about that. If you're about to file for divorce and you're thinking, maybe we would want to separate first before we have those parenting agreements in place, speak to an attorney right away before you pull that trigger and possibly set yourself up for, a downfall relatively soon after you guys physically separate. So if you're looking for similar answers to questions like these, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.